Imagine this. You're on death row for a murder you swear you didn't orchestrate. Your entire fate was sealed by the testimony of the one person who actually committed the crime. Well, for Richard Glossip, this wasn't a hypothetical, it was his reality for decades. But his case took such a wild turn that it ended up in front of the U.S. Supreme Court, forcing them to question the very foundation of his conviction.
So how in the world does a murder from 1997 end up completely dividing the Supreme Court all these years later? We're going to walk through it all. We'll start with the original case against Glossip, then dig into the new evidence that blew it wide open. We'll look at the huge legal question at the heart of it all, see why the majority decided he gets a new trial, and finally unpack the really sharp disagreement among the justices themselves. All right, let's dive in.
Okay, so to really get what the Supreme Court was dealing with, we have to go back, way back, to the very beginning, to the crime that kicked off this whole decades-long legal saga.
The story starts in January of 1997. A hotel owner, Barry Van Treese, is found beaten to death. Pretty quickly, the police get a confession from a maintenance worker named Justin Sneed. He admits, yep, I'm the one who swung the bat, but he points the finger at his boss, Richard Glossip, and says Glossip paid him to do it. So Glossip goes on trial, gets convicted, but that conviction gets tossed out. Fast forward to a retrial in 2004, and the state's case is once again all about Sneed's story. And once again, Glossip is sentenced to death.
And listen, this is the absolute most important part to understand. There was no physical evidence, no DNA, no fingerprints, nothing connecting Glossip to the actual murder. The state's entire case for a murder-for-hire plot hung on a single thread, the word of the guy who actually did the killing. Sneed's credibility wasn't just part of the case, it was the case.
So here was the deal Sneed got. Testify against Glossip, and you get to avoid the death penalty yourself. It's a classic deal with a star witness. For the jury, it really came down to one question. Do you believe this guy? And for almost 20 years, the official answer to that was yes. Until, suddenly, it wasn't.
For nearly 2 decades, that really seemed like the end of the story. The case was closed. But then, new information started to bubble up, and it started to pull at the threads of this conviction, raising some really serious questions about what actually went down.
First, a group of Oklahoma lawmakers, we're talking Republicans and Democrats, got worried and hired an outside law firm to take a look. That firm's report found grave doubt about the conviction. Then, the state suddenly produces 8 boxes of old case files that the defense had never, ever seen before. And this led to something truly stunning. Oklahoma's own attorney general, the top law enforcement officer in the state, did a complete 180 and said, you know what? This conviction is flawed. Richard Glossip deserves a new trial.
And buried inside one of those newfound boxes was this, a simple, handwritten note from the lead prosecutor taken during a meeting with her star witness, Justin Sneed. On it are 2 little scribbled phrases, on lithium and Dr. Trumpet. Seems like nothing, right? Well, these 2 little questions would turn out to be the key that could blow the whole case wide open.
So that little note, it ignited a massive legal firestorm. And it all centered on a really fundamental rule in our justice system. What is a prosecutor required to do constitutionally when they know a witness is lying up on the stand? This whole thing boils down to a legal principle called a Napue violation. It comes from a Supreme Court case way back in 1959. And the rule is actually pretty simple, but it's incredibly important. The government cannot knowingly use false testimony to convict someone. Period. If a prosecutor knows a witness is lying, they have a duty to stand up and correct the record for the judge and the jury.
And here is where it all comes to a head. On the witness stand, under oath, Sneed claimed he'd never seen no psychiatrist and that he was only given lithium by mistake when he asked for cold medicine. But that prosecutor's note, it pointed to a totally different reality. That Sneed had, in fact, been diagnosed with bipolar disorder and was prescribed lithium by the jail psychiatrist, a Dr. Larry Trumpka. You know, Dr. Trumpet sounds a lot like Trumpka, doesn't it?
So this massive conflict goes all the way to the top. And in a move you almost never see, Oklahoma's attorney general actually argued right alongside Glossip's lawyers, telling the 9 justices that the conviction was rotten and had to be thrown out.
And the court's majority, in an opinion penned by Justice Sotomayor, they agreed. They ruled that the prosecution knew, or at the very least should have known, that Sneed was lying about his psychiatric treatment.
And their failure to correct that lie was a flat-out violation of Richard Glossip's constitutional rights. For the majority, this lie wasn't just some small, insignificant detail. The legal term they used was material, and that's key. Because Sneed's testimony was the only thing directly pointing to Glossip, his credibility was literally everything. Any lie that could make a jury doubt him was, as the court said, necessarily determinative.
So let's break that down. Why did this specific lie matter so much? Well, for one, it would have shown the jury plain as day that Sneed was willing to lie to their faces under oath. 2, it just completely shreds the prosecution's story. They painted Sneed as a Rottweiler puppy, kind of goofy and harmless unless his master, Glossip, told him to attack. But if the jury knew about a bipolar diagnosis mixed with Sneed's admitted meth use, well, that could paint a picture of someone capable of explosive violence all on his own.
So because the lie was so important, because it was material, and the prosecution just let it slide, the Supreme Court said the conviction cannot stand. They reversed the lower court's decision and sent the case back. And what that means is, after all these years, Richard Glossip is entitled to a new trial.
But, and this is a big but, this was not some simple, happy, unified decision. Not at all. While the majority sided with Glossip, several justices pushed back hard. It created a really sharp and very public divide on the nation's highest court.
Justice Barrett, for example, kind of split the difference. She agreed that the lower court in Oklahoma definitely got the law wrong, but she argued that the Supreme Court was overstepping. In her view, the court's job isn't to play detective and figure out what the facts are. She thought they should have sent the case back down for the lower courts to investigate further, not make the call themselves.
Then you have Justice Thomas, joined by Justice Alito, who came out swinging. He wrote this blistering dissent, basically accusing the majority of twisting the law to get the result they wanted. He argued the court had no business even hearing the case, and that on top of that, the majority was just plain wrong on the facts.
So the dissent's argument really boiled down to 3 things. First, procedure. They basically said we shouldn't even be hearing this case because of state rules. Second, the lie itself. They argued that Sneed's lie about lithium just wasn't a big enough deal to have actually changed the jury's verdict. And third, power. Just like Justice Barrett, they felt the majority went way too far by just ordering a new trial themselves.
So after 2 trials, nearly 3 decades on death row, and a fractured Supreme Court ruling, the Richard Glossip case leaves us with this huge, lingering question. In a system where a person's life can literally hang on the word of one single compromised witness, how certain can we ever really be about justice? And what does it mean when the truth, or at least a different version of it, comes out decades too late?